right. Welcome, everybody. This is the Franklin County Fiscal Court work session for August 12th, 2021, and we welcome you here. And unfortunately, we're back in the COVID protocol, and we're doing our work via video conferencing, and we hope that we can get back to normal as soon as we can, but we have to be careful. So that's where we are today, unfortunately, and we hope that this changes soon. But with that being said, we call this meeting to order. And the first item on the agenda in the work session is authorization for approval of minutes from a regular meeting of July 23rd, 2021. And any discussion on the minutes? Okay, the next item for discussion is authorization to approve the county clerk's amended 2021 annual order, setting maximum amounts for deputies and assistants. Clerk Hancock is on. Welcome, Jeff, and we'll let you talk about the amending the order.
Good afternoon, Judge. Good afternoon, Court. It's good to see you. It's unfortunate that we're not in person. I hate that. I'd rather see your smiling faces, but I understand the situation. This is simply adding money for 3 retirements. We had fairly substantial retirements that happened. One is happening at the end of the year in December, and the other 2 have happened beforehand. This is paying out their allotted vacation money and comp money. It is not adding to another position. It is not adding to anybody's salary. It is simply, to simply put it, it's paying out our required fees that we have to pay out. I don't think we'll use it all, but I'd rather be safe than sorry and not have to come back to you 2 or 3 times. So.
Okay. And 1 is already left, and then 1 is going to be leaving in December. Is that right, Jeff?
That is correct, Judge.
Okay. All right.
Actually, 2 left. I have one that one went private sector for a better paying position. Another one went to the state for a better paying position. And then we lost the other one to a retirement. She'll be a huge loss, but when you have huge losses, you have huge payouts that go with them. So.
Okay. All right. Are there any questions for our county clerk on amending the budget $20,000 for these payouts for retirement? Squire Muller.
Thank you, Judge. Hey, Jeff, will all 3 of these positions be filled?
Yes.
Will you be hiring all of them back?
I am hiring back, but Squire Muller, what I'm doing at this point is trying to hire at the bottom and raise and elevate everybody throughout the levels. I'm trying to bring up some more mid-level supervisors along the way, and we're trying to make sure that we're enticing the people that do work with the county clerk's office to stay with the county clerk's office by being able to move them up in the ranks. So we're trying to bring them back in at the bottom and elevate the people in the middle back up to the top.
I like it. Thank you.
Okay. Any other questions for our county clerk? All right. Seeing none. Thanks, Jeff. We'll be putting that onto vote session in just a little bit.
Okay, thank you, guys.
Okay, thank you. The next item on the next 4 items on the agenda are for Robert Hewitt, and this is how busy planning and zoning is that right now the planning and zoning session is meeting across the river, and Robert will take these 4 items, and after that discussion, he'll be crossing over to the river and join the planning and zoning session. So Robert, we'll start off with your second reading of an approval of an ordinance amending the Franklin County Code of Ordinances, Chapter 155, wireless communication facilities by adding small cell systems and towers. Welcome, Robert.
Thank you, Judge, and good evening, Court. So this is second reading of the amendment to the existing telecommunications ordinance. This addresses the new 5G technology. The devices implemented are referred to as small cell towers or small cell systems. They typically go in more dense urbanized areas attaching to existing utility infrastructure, such as light poles or utility poles. The FCC does require that we regulate these separately from the very large typical cell phone towers. This did go to the zoning update committee on 6 different occasions. The city did hire a consultant, an attorney who specializes in telecommunications law, who assisted both city and county staff with preparing this document. The planning commission or the zoning update committee did recommend approval of this amendment to the planning commission, and the planning commission is now recommending approval to the fiscal court by their vote of 10-0. I'm happy to answer any questions.
Any questions on this particular item of amending an ordinance? See no questions. Robert, let's move to the second one. It's the first reading of an ordinance.
All right, so this one is specific to mini warehouses, or otherwise known as self-storage facilities. The county's current regulation allows them as permitted activities in the agricultural zoning, and then the industrial, commercial, and industrial general zoning. The city of Frankfort allows these also in the highway commercial district, which means that they're located along major arterial highways with high visibility and large traffic volumes. I felt as though it was appropriate for the county to allow those as well. And so I proposed this to the zoning update committee as an item with noted special condition number 7 that is located in your packet, which provides a series of development criteria that the site would need to address before it's allowed in that highway commercial zoning district. The planning commission did hear this item and also has recommended approval to the fiscal court with noted special condition number 27 added to the table.
All right, questions, concerns? Squire
Yes,
Blackburn?
Mr. Hewitt, does this apply to the designated zoning in general, or is this going to be a special condition, special use?
It'd be a special noted condition.
All right, so it'd have to come before the planning commission every time somebody wanted to do this in that zoning designation?
Let's see, bear with me. No, the noted special conditions are administrative. In the event that an applicant cannot meet this condition, then they would go to one of the boards.
Okay,
So they could apply for either a waiver or a variance, depending on which noted condition, A through D, that they either request relief from or were unable to comply with.
okay.
All
And a
right.
development plan would be required.
Okay.
So was this predicated by a request from a landowner in that zoning designation?
I did have some conversation with landowner, with 2 landowners in that designation. But probably more so, I feel as though agricultural zoning is not the best fit for storage warehouses. And I'd kind of rather get them back in to the highways, if you will. I mean, I understand the need, for something out in the county, but I think it's a commercial / industrial use, and I don't know that ag's best for it. So let's get it back let's allow it in a commercial zone. That was my whole thought. Because we process quite a few in the ag district.
So I guess what I'm saying, you said it's an administrative call once it gets to that, if we were to change this. So people that are in that zoning designation of commercial highway would be able to do this if they came through your office.
Correct.
Okay. All right. Thank you.
Thank you.
Squire Sebastian?
Thank you, Judge. I just wanted to follow up on Squire Blackburn's question. Is it typical for conditional uses like this then to be administratively, I guess, reviewed and ruled upon? Or is this something that would typically go back to the planning commission? Squire Blackburn, I think where he was, I just wanted to pick up on what he was saying.
So this is not a conditional use. This is a permitted use with noted conditions. So there is a distinction there. That's
So
why,
could you elaborate on what the distinction is, just so we understand? Because it seems semantically similar.
well, semantically, it may seem similar, but per the code, it's completely different.
Exactly, which is why I said it seems semantically similar, but if you could elaborate, that would help us very much to understand the distinction. Thank you.
Sure. So conditional uses are not an administrative action for county staff. That does require review, consideration of the Board of Zoning Adjustments, and in certain cases, the Planning Commission. Those are clearly identified as conditional uses, whether it be in their district description or in the land use table. A noted special condition is just an added element to what is otherwise a permitted use. So for instance, there's a noted special condition in the ag zoning that says you can have more than one home on a farm if that home is for a family member or a tenant farmer. Okay, so that's just an administrative action. If someone comes in for another home, I can sign off on it. So just a noted special condition is saying, hey, here's a little something else you got to do, but it's a permitted use if you can do it. Does that help?
I think so.
Okay.
Thank you for helping clear up. They, as I said, they are very semantically similar. So
Yeah.
that is helpful.
Yes, it can get confusing. And the noted special conditions list is part of the land use table. Okay, so it's in Article 4. Conditional uses are in Article 15. Well, those are the former numbers. Sorry, we're codified now. But section 155, if you will.
All right, Tracy has a question.
He answered it. Thanks, Judge.
Okay. Anyone else?
Squire Booth.
Who?
Squire
Squire Booth, okay. Squire Booth, sorry, I didn't see you.
Yes. I'm concerned about the buffer zone between especially the storage, self-storage places and neighboring land. Is that is a condition, right?
Yes, ma'am.
Right.
So it has to be 30 feet wide, parallel to the property line, with a double row of staggered evergreen green trees spaced every 15 feet on center.
Thank you.
Yes, ma'am.
Is Robert, is the adjacent property owner aware of that buffering? The requirement of the buffering?
Well, I mean, not unless they either contact our office or look the code up.
Okay.
Now, that is a very typical screening requirement through our ordinance whenever a non-residential activity abuts a residential zone or land use. So there doesn't even have to be a home there, and I still require it if the zoning is residential in any form.
Okay. All right, Squire Muller, you had your hand up, your hand first.
Thank you, Judge. Hey, Robert, when you said evergreens are required, what's the minimum height on those?
Typically, it's 6 feet. I don't think we have that in this regulation, but in other portions of the code, it's 6 feet at the time of planting.
So that will be required by anybody proposing, correct?
Yes, sir. For consistency's sake, that's how I'll administer it.
Okay, so I'll make sure. Thank you.
But I'm happy if you all would like to, since it is first reading, I think Councilor Sparks can advise, but if you want to add that language, I have no objection.
I personally would like that, just so something doesn't fall through the cracks, just on this, air of caution.
Oh, I agree. I'm happy to do so if the court agrees to it.
Can you add also, Robert, that they have to be living for at least 1 year?
No, sir, they have to live forever.
Okay, so they're okay.
Yeah.
So they have to live forever. If they die out, they have to be replaced by that's even better. I didn't know we could do that. Ooh, wow, that's much better.
And by requirement of the development plan and the plantings to be shown, the development plan is the binding document that gives the authority for enforcement.
Okay, that's awesome.
So they have to maintain that buffer.
All right. Squire Sebastian.
Thank you, Judge, and I appreciate Squire Muller's question. I had my hand raised for the same thing, so I just want to make sure I understood about the buffer zone. So the plantings have to be the evergreens have to be 6 foot at the time of planting. If something happens to them, the owner of the property where the buffer zone is has to replace. Do they have to replace with a similar or same? So for example, if I owned this property and an evergreen died out 10 years in, the rest of them at that point were 30 feet, I would have to replace it with a 6 foot evergreen. Is that right?
That is correct. Minimum. yeah.
Okay. I just want to make sure I'm trying to understand, not similar at the time, not the same size at the time of death, but always the tree, but at the time of planting, right? Okay.
Correct.
Thank you. Thank you very much. I just want to make sure that was clear. Thank you.
And because of their evergreens, if one or more die out, there's a reason for it. And I would want to investigate as to why it might be. Could be a drainage problem. Evergreens don't like wet feet. So I don't want people throwing good money after bad, but if a different type of evergreen can take the condition better than the other, then I'll consider a substitute after I've done some research on it. But typically it's the same plant material.
Squire Blackburn.
Yeah, so Robert, you said special condition use 27. So we would amend use number C or letter C for to make the 6 foot, have it in writing, and to be replaced within 10 years if it died or whatever.
No, not 10 years. No, sir. It needs to be replaced when it dies.
Oh,
yeah,
like forever in
perpetuity.
Yes.
Okay.
Yeah.
Great.
Yeah. So if we, yes, sir. So on item C, if we could, where it says staggered planting of evergreen trees, 6 feet tall at time of planting, spaced every 15 feet on center.
To be replaced if they were to die.
And we, if you would like, we can add that language. That's not a problem. We can in the next sentence we can say, any dead or diseased trees, shall be replaced in the same manner as the original planting.
So will you add that in for the second reading then, Robert?
Yes, sir. I sure will.
Okay. All right. Any other questions? Everybody good? Okay. You all right, Robert?
Yes, sir. I appreciate everyone on that.
Okay, I'll go to the next item. The next item is the first reading of an ordinance amending the Franklin County Code of Ordinances, Chapter 155, Table of Permitted Uses, to include the land use of kayak and canoe water trailhead launch and pickup parking as a conditional use in the limited commercial zoning district and section, and conditional uses to add a condition. I'm going to say this. I think we all need to be upfront, transparent about this. This is a amendment to an ordinance requested by Squire Muller and his family, their property. So, Rick, I ask you, is Squire Muller allowed to vote on this?
I think that Squire Muller's got a conflict on that, given the request and the information in the file or in the hearing with planning and zoning.
Yeah, but I'm fine. Not.
And I know Michael knows that. He's crossed this bridge on it a couple times, so that's nothing new. Not giving any bad news or anything.
Yeah, and secondly, and I'll get to you in a second, Squire Tracy. Secondly, this is one of those issues that we did a contract with Bluegrass Ed, Robert, for conflicts of interest, and allowed them. They're doing this work. Is that correct?
That is correct. They performed the analysis and presented at the hearing.
Okay, I just want to make sure everything was out front as we go through this. Squire Tracy?
Thanks, Judge. Is Natalie from the ad going to be with us tonight to talk about this?
No, sir. The public hearing was closed at the planning commission meeting. The reason I'm presenting it tonight, because it's simply the presentation of the ordinance and no additional analysis is being performed.
Okay, so just a couple quick questions. Someone that represents a large portion of Elkhorn Creek, are all canoe, kayak launches and pickup parking, are they subject to this, or is it just per zone?
It would be per zone, so all new activities would be subject to this. And of course, it would exclude any local, state, or federal governments
Correct,
from
correct,
installing
okay.
these ramps or anything.
Okay, so moving forward, if someone has a launch, they have to come and they have to basically apply for that. Is that correct?
Yes, sir.
Okay. And it does, are you saying it doesn't matter what the zone is? Is that what you're saying?
Well, this amendment is specific to kayak and canoe launches and parking in limited commercial zoning districts.
So, okay, I get that, but I'm going back to, so is that because of the particular zone? Or is this something that's going to be, that is required throughout the county in regards to launching canoes, kayaks, pickup parking? Is it all because of the zone, or is that something that we are requiring throughout the county?
Well, this request was based on an application for the text amendment from a citizen, okay? They proposed this activity in this specific zoning district. If this is approved by the court, it would apply countywide to any request for this activity in the limited commercial zone. Now, the land use table of the county's zoning regulations has a separate item for boating and beaching areas, but this would be separate from that.
Boating and beaching, is that because motor, non-motor, or?
I
If you
believe
don't
so.
care. Okay. And then Mr. Boggs, in here, it says, Mr. Boggs stated, he talks about approval from the health department and Fish and Wildlife. Is that all in regards to bathrooms? Does that include porta potties, or is that just, I guess, facilities that are inside of a location?
That the language relating to Fish and Wildlife, Division of Water, were specific to outdoor activities associated with the launch and or parking. That language was proposed by the ad staff. As you will look down further in the minutes, the language was modified in the last paragraph prior to the vote. So you can see there where it says it's specific to adding the word approved if necessary or required after the word Department of Fish and Wildlife approved.
Okay.
So that's,
And yeah, totally get it. And just to circle back, any other kayak or canoe launches in Franklin County, are they required to have bathrooms?
if they are being proposed under this ordinance, it's only if the Health Department or Fish and Wildlife require it.
Okay. So
Or,
basically,
excuse me, I'm sorry. Yeah, if required or if necessary. So if someone proposes to have restroom facilities, whether it be temporary or permanent, it would require approval at a minimum by the Division of Water. The Health Department, and possibly Division of Water.
Okay. So if they ask, yes. If they don't ask, they're okay. Is that what you're saying?
Yes, sir, that's correct.
Okay. Okay. All right. Thank you.
Yes, sir.
And Robert, one more thing. We're not voting on this tonight, correct?
Correct.
Okay. Just make sure. Okay. Thank you.
Yes, sir.
Squire Blackburn.
Yeah, thank you, Robert. You got your hands full with all these tonight. So this conditional use is for this particular zoning condition, right? Or zoning designation. Do we have these or this type of conditional use in other types of zoning designations, or is it just for this, the commercial limited district?
Well, like I said earlier, we do have boating and beach areas in the table of permitted uses. Bear with me as I pull that up. I'll let you know what zones those are allowed in. So boating areas are conditional use in the agricultural zoning, the highway commercial and highway general districts. And that was under private recreation, and they're conditional under the same categories under public recreation.
So the launching, is it only really addressed under just this rural limited commercial district designation?
Yes, it is. Because
Okay.
So boating areas, I would have to go through the SIC code to see if it further categorizes whether or not that includes marinas.
Okay.
So yeah, the language in the code just simply says boating areas.
So if somebody has a piece of property and they want to propose a launch site, they would need to come to you, and we'd probably have to do a text amendment to a different zoning designation to make it okay in that designation as well, or at least weigh it.
Yes, sir. Anything outside of this CL zoning would require, going back before the zoning update committee, back to the planning commission, and then back before, the fiscal court. So, while other zoning districts could have been proposed by the applicant, sometimes it's like, why muddy the water? Let's start it out simple and let's see how it goes.
Right. So if this passes tonight and we have somebody in the future in another rural limited commercial district want to do this, would that be an administrative action, or would for a conditional use, or would they have to go through the planning commission?
It would go through the Board of Zoning Adjustments.
Okay.
So that'd be a public meeting and the adjacent neighbors are notified, and I put an ad in the newspaper.
Great. I'm just trying to wrap my head around it, and I'm sure there's other folks that are curious, because this is a great idea, and I think other people are going to catch on and want to do it as well. So I just want to make sure that anybody's listening tonight would know which avenues to take to have the proper process.
Sure. Now, there is a provision in the regulations to avoid duplicate hearings if a zone change request, in this case, let's say to limited commercial, also involves a conditional use, let's say a kayak and canoe launch. The planning commission then is granted the authority to consider the conditional use permit. Okay, so that just helps speed the process along, as fast as planning and zoning can move.
Sure. Awesome. Thank you so much.
You're welcome.
And Robert, even though this particular ordinance is pertaining to Elkhorn Creek, it's the same as if it were to go on the Kentucky River. Is that correct?
That is correct.
Okay.
Benson Creek, Kentucky River, Elkhorn Creek, wherever. Yeah. So this is specific to zoning, not per se not the water body.
Okay. Okay, doke. Squire Tracy.
Thanks, Judge. Robert, just to circle back, a lot of this is based on them coming back and asking for this zoning, correct?
Use.
I don't understand.
So if they don't come to you and say, hey, I'd like to do this, it's not coming in front of you. So that's what I was asking a while ago. A lot of times you don't know that this is even happening. So as far as zoning, but it happens.
Well, if enough vehicles show up, someone's gonna let me know, I'm sure. I mean, we know where people congregate, and we're aware of places out in Peaks Mill where, there is a dedicated pickup place for Canoe, Kentucky, and that there's large volumes of traffic later on down the creek, you know, if a certain area births itself as a launch that people start to use, well, then zoning's going to come by and say, whoa, wait a minute, you know, this is a constant thing, and your zoning may or may not be accurate, and even if it is, you need to go through a process. So
Right. No,
you know, it becomes an enforcement issue. Yes.
Hey, you said it, I couldn't agree more, but just what I'm trying to say is, like, I know the road department supervisor receives phone calls. I receive phone calls about parking and so forth. And so I'm just trying to make sure everybody understands exactly what's going on.
Yes, and you know, just a little, you know, just some observations of an activity can help confirm whether or not it's just people parking to get in the creek to go swimming, or if it's a true, you know, launch site for kayaks. You know, so it's you know, if this passes and those activities occur, call to my office is what it takes, and I'll look into it. So you know, if this passes this evening, or excuse me, by the fiscal court, it still requires board approval, Board of Zoning Adjustments approval for a conditional use permit, even if the property is already zoned limited commercial. Okay, so if you all approve this, it doesn't mean every property with a CL zoning gets a boat launch. It's not.
No, I agree. Like I said, that's why I kept asking. They have to come. They should come back in front of you if this is something one. Yeah, access is needed. Very badly.
So yeah, so the conditional use allows the Board of Zoning Adjustments to consider the conditions already established in your zoning regulations, which the planning staff analyzed as part of our technical analysis and report to the board. The board can also impose any conditions they deem appropriate to that use for a specific location. All right. So for instance, they could limit the hours of operation. They could limit the number of vehicles to be parked, things of that nature. So, you know, it also allows for the opportunity for neighbors and the general public to hear the proposal and speak either for or against it. So it brings the issue to the public forefront. Okay. So I think that's a good thing.
Thank you.
Robert, several magistrates have said on the voting tonight, this is first reading and there will not be a vote tonight. Being a first reading will only be heard tonight. The voting will be on September the 2nd.
Yes, sir.
Okay. Any other questions on this item? Seeing none, let's move to the next one. And this is also a first reading of an ordinance amending table of ordinances, zoning map changes to the Franklin County Code of Ordinances, a 10.1 acre or 10.01 1/10 acre property identified as PVA map 051, located at 505 Jones Lane, from rural residential district RR to agricultural district AG. Robert?
Yes, thank you. So this property is on the Jones Lane in the southwest part of the county, not to be confused with the other Jones Lane. So the applicant is requesting an RV park at this location. Your county regulations view that as a campground. And so therefore camps and campgrounds are conditional use in the agricultural zoning designation. So the applicant has requested a zone map amendment from rural residential to agricultural district. As I mentioned before, the planning commission having the authority to consider conditional uses. The applicant made that subsequent or that simultaneous filing for a conditional use, and the planning commission did hear that at their July meeting. So the planning commission has recommended approval for this activity. The applicant did disclose their intended use as the campground and did provide a drawing for the planning commission to view, and I believe that has been included in your packet. That is a preliminary layout proposal, so it's not a document that is prepared to be signed at this time. There are still some other issues to be resolved specific to utility connections and site layout and stormwater drainage and the like. So the planning commission has recommended approval to the fiscal court, and it looks like it was a 9-0 vote, and this is first reading of the ordinance.
Robert, I've gotten some emails from concerned residents about the width of the road. Did you and John Mitchell go out and look at the road itself?
Yes, sir. On Monday of this week, county staff, including myself, Road Superintendent John Mitchell, Fire Chief Kevin Hutcherson, and Assistant Fire Chief Mr. Brewer, along with the applicant, Mr. Turner, Mr. Ryan Turner, and his legal counsel, Charlie Jones. We met on site to review the road conditions itself, and to discuss any concerns that the agencies may or may not have. The concept plan shown in your drawing, and I'm not sure how well you can read it, but it does provide a road cross section specific to Jones Lane that identifies the asphalt width between, I think it said 22 and 24 feet. It's not striped, but the road is straight and flat, and there does not appear to be any sight distance issues at the proposed entrance location to the subject property. So I'm sure Mr. Mitchell is on and can speak to his review of the conditions out there and speak to the court as to his opinion on the road condition to accommodate an RV park.
John Mitchell, are you on? I think you had some video issues, but are you on with audio?
Can you hear me?
Yeah, we can hear you, John.
That's amazing.
Yeah.
Yeah, we looked at the road. I mean, average, it's gonna run, within our standards of the 18 feet. I don't know, how many will be going in and out there every day, but I wouldn't think it would be constant traffic. There's room to move around there. I don't see that big an issue with it, really.
Judge, if I could, I would like to say that I pulled the minutes up, and there was testimony by the applicant's attorney that the roadway width measured in several locations was 18 to 22 feet of asphalt width.
Okay.
I would like to add that this is not your typical RV campground. There was testimony at the hearing that this market will be for those extended stay guests, whether it be traveling nurse, a contractor, or anyone looking to stay, weeks to a month or so. There was testimony provided by another owner of a campground in Franklin County who cited the need for this type of use, and that at his business, he has a backlog of individuals wanting long-term stays that he cannot accommodate. And he had no objection to this applicant's request for this use, and said it's needed in our community. So in terms of traffic, I don't foresee it as a lot of in and out. At least that's not how it's being proposed.
Okay, Squire Tracy, I think you were first. Let's go with you first.
Thank you, Judge. Robert, you made mention that the road was 18 to 22 feet in several locations. Does the road ever go below 18 feet?
Mr. Mitchell, does it? I don't believe it does, but not up to this site, does it, John?
No.
It may narrow as you get on towards the back.
Okay. And then you're mentioning the long-term stay. Is that, and I think I read in here that it talked about a storage tanks for wastewater, gray water, black water, what they call it in the camping world. So these sites aren't going to be full hookup sites. They're not going to have sewer at the site.
It will have sanitary sewer to be connected to the city system.
So you're gonna have 99 separate spots?
No, sir, I believe that they'll have a dump tank, but it will be connected to the city sewer system. There's a manhole at the northeast corner of the property.
Okay. 99 sites, I would assume there'll be 99 spigots, water spigots,
Yes, sir, and electric services.
electric services. Okay. Water line can handle that. The water line can handle that?
We did send out a facility review. Those should be included in your packet. Don't remember off the top of my head what Farmdale said. I'm looking real fast. There is a water line upgrade in design at this moment, scheduled to potentially go to bid this spring. HMB is the design engineering firm. They will be upgrading Farmdale did respond on May the 13th. Says Farmdale. Okay, did you see it? Okay.
Yeah, I've got it. I was just asking questions. Okay, so 18 to 22. Is there 18 to 22 foot? Is there a turnaround spot? Are there pull-off spots? If a camper pulls in, which is all hours of the night, obviously going camping, we all realize that. But is there pull-off spots or enough room to turn around if they come down the wrong road, and or if they hit or if they meet another camper and or school bus, fire truck? Is the road able to handle that?
I believe it is. Mr. Mitchell, you're the road superintendent. What are your opinion?
Yeah, I think it'll be fine. There is not a designated turnaround at the end of that road, but I don't see them passing it up because there's nothing really past it. So it should be fine. I mean, yeah, it may be a little tight in a spot or two, but it should be fine.
Okay. Well, and like I said, the only reason I ask is the maybes and the should be's, and that all comes back to bite us. In regards to Mr. Judah responded, he didn't believe all units would be occupied at one time. Well, if he goes to Elkhorn Campground's occupied just about every day of the season. So that concerns me with the traffic. Again, wouldn't be long to be out there widening the road because, I mean, John, you drive those big trucks, you pass them on roads with no shoulders, you know what you get. So that's some of my concerns.
Squire Tracy, based on some information from the RV world, average width of a motorhome.
8 foot 4 inches.
I'm sorry?
8 foot 4 inches.
Yes, sir. That's correct.
So, yeah, but that don't include mirrors and so forth. So, and when you're talking big, nice motorhomes, they don't like driving them up against tree limbs. So most of the time they take the middle of the road. So that's why I'm asking.
Robert, I'm gonna get to the Squires for a second. We have 2 or 3 RV facilities in Franklin County, one at the Forks of Elkhorn, 1 or 2 down on Kentucky River Campground and Strohmeyer's. John Mitchell and Robert, I ask you all this. What are the roads like to those 3 RV facilities? Any better than this than here on Jones Lane, wider than, narrower than, windier, or anything else? Or is this pretty standard road, pretty nice road compared to those? I don't know. I'm just asking you all that. John Mitchell, can you respond to that? Since you live out in that area with Strohmeyer and Kentucky River Campground?
Yeah, Kentucky River Campground is just, I don't know, windy, I'd say. It is a little wider in most spots. The Strohmeyer's is worse, it's narrow. The Elkhorn, of course, we did a upgrade on that road several years ago. It used to be really bad, but that road was only about 12 feet wide originally. But now we're at 20, so that made a big difference.
Okay.
Judge Wells, if I may,
Yes, sir.
before the county attorney says it, this is consideration of a zone change. I believe the court, their
Getting
purpose of this is
evidence.
to determine the appropriateness of the zoning based on the applicable regulations, not necessarily how the site is to be developed.
I apologize. I apologize.
No, that's fine. I just, I see Mr. County Attorney is on the screen.
Yep. That's what Robert said. That is correct.
Okay. Squire Muller, you were next.
Thank you, Judge. So, Robert, question from Farmdale, when they said they're upgrading that 6-inch water line, and then I noticed Chief Hutcherson states that hydrants need to be every 500 feet. Is that something that we were doing in that area anyways, or what's the status of that?
I do not have a copy of the plans to see if Farmdale is proposing any hydrants in their project. The county does have, and the chief can comment if you'd like, but I think there are some funds allotted every year for the installation of hydrants where the chief believes they're needed. And then lastly, the county regulations do have the ability to require the installation of infrastructure such as a hydrant relating to a development.
Okay, thank you.
Yes, sir.
Squire Sebastian.
Now, thank you, Judge. And I have a number of questions, and I've had a number of constituents reach out in regard to this issue because as we know and we've discussed road width, and if you've ever driven down Jones Lane, you know that mailboxes are right at the edge of the roadway. And for those of you who've ever driven a large vehicle, sometimes with overhangs, as the road department does, as Squire Moore does, they unfortunately, some of that overhang takes out mailboxes and other things. So there is an issue with the width of the road, even if a school bus and or a hay wagon out there, because it is a rural, agricultural, residential neighborhood. Folks who travel on that road with 2 double-rolled bales of hay, whoever's meeting them on the road has to actually try to pull off in someone's yard to allow that hay wagon to go through. So I know there are issues with the road width. The RV parks that I think have been discussed today are typically are located on bodies of water rather than on a dead-end residential neighborhood street. They have creek access or river access. In this location, RVs, which can be up to 45 feet, and then they're towing potentially something behind it. If they have a golf cart and or an ATV, are they going to be allowed to drive on the roadway, this residential dead-end street? Are we making any kind of allowances for ATVs or golf carts in the county? I think the city has done that in some areas. But I think the neighbors are somewhat concerned because of the lack of recreational activity in this location. And then certainly there's one fire hydrant, and I think Squire Muller brought up that he thought this is a 6-inch line. This street is serviced by a 4-inch line. Certainly the water district, and I think the question that was put to the water district by our staff is, anything you can provide me to ease some of the concerns would be much appreciated. So, that seems to me to be somewhat of a leading question for Farmdale to respond back to, because they are planning to widen or add volume to water by upgrading some water lines along Old Lawrenceburg Road, off of Nineveh Road, up across down 127, but they really don't have a time frame for that because they're going to have to request a loan. But I think they are certainly making plans to do that. we also had some comment, or I did, I'll say this, today from some residents there who already experienced water issues on that roadway, who are at the end of that line. So certainly if this goes in and there are 99 spigots, we don't know when the water line will be upgraded there. If there are already problems on the number of houses that are there, that is a challenge. They are also served by only one fire hydrant, which is at the entrance of Jones Lane and US 127. There are 2 blow-off hydrants or flush hydrants back on the property, but they don't serve for fire protection and or any other purpose other than to make sure the lines are clear. So from folks who have reached out to me about the appropriateness of the zoning, and I have, you know, I guess a number of questions about that. And I'll offer the opportunity for others to jump in before I kind of go down the path of about the appropriateness, because I think that's the issue here, and I think Squire or Mr. Sparks is going to push us back in that regard. So I'll allow others to ask their questions before I get to these. Thank you.
And Judge Squire, I just would like to point out that it sounds to me, and I appreciate Squire Sebastian's concern and the other issues, none of which are in the record. If that's going to be the case, you realize there's only one of 3 criteria you have, or 3 criteria you have to evaluate this on. And if there's going to be additional information, it pushes you back to a public hearing. And the information that Squire Sebastian just provided would be appropriate, either should have came through planning and zoning or through independent public hearing by the court. None of those are contained in the record that's been established by the commission. So you can't consider those.
Squire Booth.
I had calls from not my constituents, but from residents of Jones Lane. And I have been out Jones Lane, not for this issue, but I think it's for the census. I worked for the census once. And it is a narrow road, in my opinion, and it would cause traffic problems. And I was told that the water line was 2 inches. Of course, the water department or the water district knows better and say it's 4 inches. So they're still having problems with a 4-inch line. This water line upgrades probably won't happen for 1.5 years, if then. And I just think this is it's a problem for the residents of that street. And to my information, people attended the planning and zoning hearing and were confused about the procedure and did not follow the proper procedure to speak, and they were denied their testimony. So in that case, I think definitely another public hearing or a public hearing should be instituted.
Squire Booth, Judge Wells, Mr. Jackson does a fine job conducting his public hearings, and I do not recall anyone being denied testimony at the hearing. At least the minutes do not reflect that.
Okay. Squire Blackburn, did you have your hand up?
Yes. You know, I have concerns as well. I've had constituents reach out to me, and I've had folks on Jones Lane reach out to me. Especially with the road, you know, school started back today. The buses have been making runs for a while. And today, you know, I lived on a country road. I've smacked mirrors with buses. That road's 18-foot minimum. And you got a 8'4", and you get a fire truck come in there around 100, or you get 2 motorhomes come in there. That's 1'4" left over. That's that far. That's 8 inches. So if we put 4 inches on each side of the road. That leaves nothing in the middle. That's a concern. And if they miss the pull in, are they gonna have to turn around on somebody's residential property if there's no proper turnaround? I know I totally respect and Mr. Mitchell, and I know he knows his roads, and but I know, you know, we swipe mirrors all the time, and I'm just worried that it'll be more than a mirror. I know there's things that we can take into the record or not into the record, but I think our own understanding and experience of how wide a road is and driving something down it, it's a concern. So I just want to bring that up. And, you know, I don't know. I don't want to drive down that road knowing that there's no turnaround. Or if I was a school bus driver and my kid lived on that road and they had to get off the bus, it's concerning to me. It's a safety issue for me.
Robert, do you see any reason in the trailer park that's got 2 entrances that if they did bypass the area, they would be able to go into the trailer park and go all the way around the trailer park and pull back out on the other side?
The subject property is down the road from mobile home park. So you would have already passed the mobile home park before you get to the campground.
Okay, I'm looking at the wrong map then, because it looks like it's right before the trailer park. Got the trailer park and then this one's next to it. So it's on past the trailer park?
Yes,
On the
sir.
right- On the right side going down?
No, sir, be on the left side.
On the, okay, it's on the left side. Okay, I see.
Yeah, the south side of Jones Lane.
Yeah. Is that private? Is there a private road at the end of this? A private drive?
Bear with me. It turns into, it sort of forks off. One turns into a dirt road off into a farm field, and the other turns into Wooldridge Lane.
Yeah, which is private.
I'm checking that right now. Yes, sir, that's a private
It is
street.
private.
Yeah, Wooldridge Lane is a private street.
Okay. All right, Squire Muller?
Thank you, Judge. Hey, Robert, thank you again. You know, you said before that you could put in there, if required, fire hydrants to be done by the applicant developer. It seems to me like there's a big concern from neighbors, people on this court. Would it be appropriate that, I mean, how long is the road? I mean, could the road have to be widened with a turnaround at the end? I mean, is that something that would ease everybody's mind? And I'm just throwing that out there.
It does
I mean,
not
that's
appear.
because I think like Squire Tracy was saying, I mean, we see it down here in the Forks all the time. You know, you get a $500,000 RV pulling in, another one pulling out, and it's tight, and nobody wants to scratch anything. So it seems to me like most of the conversation tonight is about the width of that road and a water line. I mean, is there something that could be, you know, asked of the developer or owner?
Yes, there's an opportunity during the development plan stage. As it relates to a turnaround, it does not appear to me, based on the county's mapping, that there's adequate right of way that exists to accommodate a cul-de-sac at the end of Jones Lane. It would be required to be, it would have to be acquired, if you will, by the county from the property owners.
So what if we took out the cul-de-sac and just asked them to widen the road? Is that legally possible?
Well, I mean, you know, once again, I mean, we should be discussing the appropriateness of the zone change, not development standards, but you know, anything can be asked of by me in the administrative process, but then it's also anything can be appealed and taken to the planning commission. So I can ask them to make it a 6-lane highway, but I know where that's going to land me. But then, once you go into road widening, now you're having to take land from the adjacent property owners and the like. And so it's sort of a snowball effect. And then, anything can be asked of.
Okay.
Whether it's agreed to or not is a different issue.
Okay, thank you.
But I'd remind the court again, and I appreciate the testimony from all of the squires supplementing the record. You're stuck with a situation, number one, where you got the commission recommending the zone change. The standard for your application is not what's going to go there, what they're going to do, what the questions are, et cetera. It's going to be based on the report and the evaluation, whether or not the proposed modification of the zone classification is consistent with the plan as it stands. And if it's not, whether or not circumstances have changed to such that it would render the current zoning inapplicable, or whether the original zoning, given the circumstances, is inappropriate and was wrong. The other things that you want to delve in, which are very important and they're very critical, it's going to require you to do one of two things. Number one, you got to trust the commission and the administrators as they evaluate the actual conditions, the lay of the land, the development plan, et cetera. But more and most importantly, if you're going to bring those particular, and I said testimony, and it's pretty close, unsworn, but all of those other facts and informations and engineering and roads and hydrants and right-of-ways, et cetera, those would have to come out by an additional hearing, because those things were not, all of those things were not presented at the original matter before planning and zoning. You could also, if you're going to go a different route, you can request a transcript. But I would note just the things that the court discussed just then about and brought up, they were all things that, from my review of the record, were not presented at the time. Constituent concerns, phone calls, whatever you want to talk about. So again, just remind you that the elements of your review and evaluation and the means to do it with that kind of new information is going to be have your own hearing with your own findings of fact, because the commission had findings of fact which said it was appropriate. So be careful and just go ahead and, if you're going down that road anyway, no pun intended, get you a public hearing on it and add
Robert,
those things to the record.
how long will it take to get a transcript?
Well, that's difficult to say. Depends on availability of the court reporter. I will like to add that, as I mentioned earlier to the court, this applicant took the opportunity to have a filing for a conditional use permit at the second reading of their zone map amendment request. The commission heard their conditional use permit request and has approved it with the staff conditions, which total of 5. Also subject to the development plan coming back before them for their review prior to it being reviewed. So I guess if the zone change doesn't occur, then I guess the conditional use is null and void. But as it stands now, if the fiscal court approves the zone map amendment, they're granted a conditional use permit.
Squire Sebastian?
Thank you, Judge. And I wanted to get back to our counselor's point. I'm looking back through documentation that was provided on our packet in regard to rural activities, and it enumerates things like growth in these areas should be closely considered with an awareness of the value of the ecosystem services which they provide. Given that these areas are considered undeveloped, they may be suited for some types of very low density, intensity development, including large lot residential uses, cluster conservation, subdivisions, and agriculture. I think I heard our planning director said that this was, I guess, a permitted use because it falls under, did you say a campground or camp? Because otherwise, I'm just kind of trying to get back to the points that our counselor is making in regard to, since this is it talks about non-residential uses may locate or be appropriate at intersections of primary roadways. certainly this does not meet that criteria because it is not at a primary roadway. And I have flagged a number of things in my document here to, I guess, get back to our counselor's point of view in regard to saying that this is somewhat, doesn't meet the criteria in regard to no new development shall occur where there is not an adequate water supply. It's clear there's not an adequate water supply.
Oh, no, man, but let me interrupt you here, just so there's clarification. I have no opinion on whether it meets the 3 criteria of the policies.
Right.
Well, my point was, if there are other facts that need to go into that decision that appear to be contrary in your mind or out in existence that didn't make it in the record, those have to be supplemented formally. You can't just rely on what everybody said at Croker. That was the extent of my point.
I understand. Absolutely.
Okay.
I get it. I'm just trying to go back and bring up points that were made as part of the finding of fact and raise points. But I'll defer to Squire Moore because you'll hear from me for an hour at least, unless we come to some other way to move this forward. Thank you.
Well, Judge, if I may, there is evidence in the record from the water district that there is adequate water supply. I just want to clear that up. That is in the record.
Yes, sir. But the prompting of that is, please help me find some language to assuage their concerns. That is somewhat leading.
Well,
And we have information from residents who say they already have problems at the end of the line. So when this is not upgraded for a period of years, we're going to have problems there. They already have them.
Well, if you'll take note of the date of those emails, the water district did not reply until 2 months after the initial request for the facility review was issued. So Mr. Judah was only reaching back out saying, hey, please give me some information here. And the water loss that Farmdale experiences is a problem with Farmdale. And the water line upgrade that they're doing is an attempt to not only replace the pipe material, but also reduce the water loss that impacts the customers. And it just so happens we're going to a 6-inch, which will accommodate for fire protection. But as it is today, the district says they do have capacity to serve their existing customers as well as the proposal. Just want to be sure that was clear that is in the record.
Okay, this is a first reading. And so there'll be no vote on this tonight. And we can take this to the second meeting and go from there and see where we need to move. Squire Moore.
Not wanting to say anything outside of what I should on this. This road is less than a mile long. Got a 4-inch water line. I live on a water line that's probably 50 miles long and it's 4 inches. So don't talk to me about not enough water. If someone on that road doesn't have enough water, it's because of their service to their house is not good enough. I'm sorry, but that's just the way I feel about that.
Okay. All right. So we'll continue this. We'll have an opportunity. So we'll move forward and just bring this to a vote on our September 2nd meeting. And if there's a change and if you want to move another route, then we'll be able to do it at that time. Councilor Sparks, you have anything else to say about?
I just wanted to tell the court, and I appreciate more than they know the degree of analysis that they're engaging in regarding these zone changes, because they're critical for the future of our community and that their willingness to do it right. If you roll it to the second meeting for the second reading, pardon me, then your analysis to change it has to be either on with a transcript where you've got the actual testimony presented, not just a summary, or a public meeting. Otherwise, you're kind of stuck. You have no additional evidence for which you can argue, as Squire Sebastian said, regardless of the amount of time that you can argue for contrary findings of fact, et cetera. So I'd really recommend the prudent thing would be to get a transcript in front of you while you're deliberating that if there is the degree of concern that may prevent approval given planning and zoning's affirmative findings.
Squire Sebastian wants to comment about that.
No, I just want to ask a question. So does that render us to be like a rubber stamp for this every time it comes to the court?
No, ma'am, that's why you've got the provisions to review it. But if you review it, it has to be a meaningful review. You don't have the transcript in front of you to address the findings of fact to say that they're improper. You just have the summary report and the vote. That's why it's critical to order a transcript or have your own hearing on it. It's not a rubber stamp at all. I mean, it could be, and maybe
I
it
just
has
wanna
been
be
in the
sure.
past. But
I want to be
that's
sure
the
we're not
out.
going down that road. Thank you.
Well, no, that's
So-
exactly just the opposite. That's my point. If you
Right.
don't do it right, you're rubber stamping because it's going to get kicked on you, and you didn't do it right. So if
So
you're going to go ahead and get your transcript ready and be ready to discuss that at the second reading.
So what is the appropriate forum and venue to request that transcript?
I just
Here,
asked
right
that
now?
question just a
Right
second.
here, right now. Let's do it.
We can do it right now. Yeah.
So
And you all have done those in several occasions where you're looking at it, but right now you don't have the proof. You've got the summary, so you got to either transcript it if you're going to go a different route. And just by the way, agreeing with the planning and zoning, sometimes they type it right, so it's not necessarily rubber stamping. But if you want the option to go a different direction, then you have to have a basis for independent findings of fact.
So the other question I have, Counselor, is if in some of the material I received and not only in writing, but have heard from constituents, they felt that they were not given the full opportunity to speak. I heard the planning director say that no one was, I guess, abridged from speaking, but from what I heard from the other constituents. So the question is how do we ensure that we have heard fully from the constituents? That's my concern as I serve these individuals, and I fully want to make sure I hear from them.
Well, that brings to bear two problems. Number one, in the absence of your own hearing, you're stuck with the evidence from the record. Number two, if you're wanting to supplement the record or you're going to take into consideration things that people have told you, like you just said that you want to consider, then that's a public hearing. So if that's the route you're going, that's the route to open it up for your own public hearing.
Well,
Because
that's the
even
route
when you
I'm
get
going to
your-
go.
Even when you get your transcript, I assure you, the most dangerous thing you can do
I
is to
am
say,
too.
well, I'm voting for this because, or I'm voting against this because of what was said at whatever place that wasn't on the record. That's dangerous and get you turned around. We've been through that on some cases. Don't want to do that again. If you wanted to bring other things to bear, and that's a public hearing. But if you do the transcript, you're stuck on the transcript. You can't be saying, well, I know this or I know that if it's not in the record.
Counselor
So
Sparks,
that's at
is
play.
it not appropriate for us to ask for a transcript and then at our next meeting, if we get the transcript in time, or when we have time to review the transcript, when it's appropriate, ask for a public hearing after we've gotten the transcript?
Yeah, but you've got some timelines running on you, Robert. What's your timeline running?
90 days from July 8th.
Okay, so just be sensitive to that. That has to be when it has to be resolved
Okay.
one way or the other, or it is automatically, it falls into the finding from planning and zoning.
Okay.
So I want the public hearing.
I
Do you normally
agree.
do a public hearing without the transcript, Counselor? Isn't it best to get the transcript and then do the public hearing?
If you do, the most optimal way to do that is to have the transcript plus your public hearing, and then you've got a lot of proof on there.
That's what I'm
You-
saying.
Otherwise you can't disregard the proof that it's been developed. So if you're going to have a public hearing, you got to have a transcript too, and they'll all go into just one trial packet, for lack of a better phrase.
Okay.
So you're saying do those simultaneously, Counselor?
You can either vote based on what you got, and which means approving it, order the transcript and see what your findings of fact would be based on the transcript. Or if you have a public hearing, never have a public hearing without the transcript as well, because that puts it all together. If your goal is really to maximize the information, then you do both.
All right, I'm gonna go for option 3, to do both at the same time.
Well, option 3 is getting the transcript first, isn't it? But, okay, Robert, what, do you know the 90 days date, what date in October that would be? Can you figure that out?
Yes, sir. Bear with me and I will be right back with you on that.
Okay. So if I'm going to recommend that we ask for the transcript. And at that point, if the court so decides that the transcript does not produce the evidence that you need, then we still have time to do a public hearing, because we are going to have, if they do a public hearing, you have to have the first step. And instead of doing them all at one time, that's saying that you may have enough information in there that may change your mind, or I don't know. I've got a feeling where this is going, but we have to get the transcript no matter what. So if we just ask for the transcript at our September 2nd meeting, then we can say the transcript did not provide us the information that we wanted. And so we're asking for a public hearing. At that point in time, we can do a public hearing at any time. It'd have to be a special meeting, but we can do it at any time. Is that correct? As long as it meets that 90-day period, right, Counselor Sparks?
I'm laughing because there were 51 cases in Franklin County. It's the highest number of cases we had in January. And a lot of things are acting like it's all just still normal, and it's not. So
Yeah.
please take into consideration the revamping of the COVID epidemic, because I think within 2 weeks to a month from now, just hold on what may be done to handle and address this problem. It ain't getting better, and I don't want to preach about it, but get vaccinated, mask, and socially distance. But you're going to have to be mindful of we're going to have to be flexible, much like the last one that we had to deal with in the middle of COVID.
Remember, the last one we had was a 7.5-hour public hearing, and
And don't get me wrong, it was beautiful, it was glorious, it was detail oriented, it's the way things ought to be done. But just be mindful that that's the world we live in now, and I think that's the world that you're going to be facing this hearing in.
So let's just lay it out on the line, Counselor. Can this court receive the public the document and the transcript, and by evidence that they see in the document, the transcript, on September the 2nd, say, based on these findings of fact that I find in the transcript, I'm voting against this zone change.
With separate independent findings of fact based on the transcript, that is in the realm of possibility, yes, sir.
Okay.
If there are additional facts to be brought in, much like to use the phrase the members of the court used, if there were concerns that have shared with them that are not part of the record for which they base the decision on, that would be a very dangerous course of action, and that would require a hearing because you're supplementing the record.
Could some of those facts be in the transcript, but didn't come into the summary?
That's the point of the transcript. I don't know, Judge. I'd be speculating at that point.
That's my point.
If they have made the transcript and there's enough and you believe that would be appropriate, yeah, you can do that. But the danger is bringing in things that aren't part of the record.
Yeah, but
that's just human nature.
They could find findings of fact within the transcript and say, without doing a public hearing, and say, these are the reasons I find as factual that constitute not voting for this zone change.
That is theoretically possible. Yes, sir.
Okay. Squire Blackburn. You're muted, Squire.
I know that Mr. Hewitt just said that he was going to look and see the 90 days. Would that be 90 days from the June 10th public hearing that the commission had? And if so, that would be September 8th.
No, sir. The way the statute reads, it's from the Planning Commission's final action, which would be July the 8th.
Okay.
So I'm looking at roughly October the 6th, just a quick count.
Okay. Okay, but once again, if we order the transcript, you can still vote against it based on the findings of fact that are within the transcript. The only reason to go to a public hearing is if you don't see that evidence and you want to bring in more evidence. But I think
watched the
many of
meeting.
you have already
Yeah.
seen that evidence.
I watched the meeting and I took notes, so I don't know. I guess my notes wouldn't be legal, but I think there's more to it. And I'll take the recommendation of Squire Sebastian.
Well, and that is to order a transcript, right? Okay.
Yes, sir.
All right. Squire Booth,
I really believe that the findings of fact have not included what I have heard from residents. And I believe we will need a public hearing. So I would say order transcript and a public hearing.
Squire Tracy,
Judge, what was your recommendation? Just the transcript?
that we order a transcript. You look at the transcript, decide if you can find findings of fact in there that don't allow you to vote for, or does allow you to vote for, either against or for the zone change. You don't have to go to a public hearing to do this. Remember, a public hearing is going to be I'm not against the public hearing, let's not say that. But it's going to be a difficult task because we're in COVID and people are going to have to do the Zoom. So all I'm saying is let's try option one before we say we have to do option two, because option one is a prelude to option two.
Yeah, I'm fine with you, Judge Wells.
Anybody else? Here. Squire Moore?
Get the transcript.
Okay. Squire Muller?
Since this isn't Squire Sebastian's district, I'm gonna go with her on starting to get the transcript and we'll go from there.
All right. I think we got 4 votes to do the transcript then. We'll do the transcript. Robert, we ask that you get the transcript and as quickly as possible. Hopefully you'll have that by that date and then we'll move forward from there. Okay?
Well done, Court. That's a very prudent course of action.
Okay. All right. Thanks, Squire Sebastian.
I just have one question, Judge. If our planning director, as expeditiously as he can get that transcript, can that be forwarded to us well in advance? Let's say he gets that next week.
Yes.
Can we get that as quickly as possible
will.
rather than
You will? Absolutely.
2 days before our meeting? Thank you.
You
That
will.
would be fabulous.
That will not,
Thank you very
yes,
much.
that will come to you expeditiously.
Thank you.
Okay. Robert, thank you. And good luck on crossing the river and getting there on time. Thank you, sir.
Thank you, Judge.
Okay, the next item on the agenda is approve a resolution adopting and approving the execution of a rural secondary program agreement between the Franklin County Fiscal Court and the Commonwealth of Kentucky Department of Rural and Municipal Aid, accepting all our roads and streets referred to therein as being part of the county road system. John, we go through this. We have gone through this before. You want to talk about it? John Mitchell?
Yeah, I'll try. This is our portion of the state's money, the flex money that we get every year. It actually went up about 10,000 this year, so that helps out a little. So I just put a list together real quick and throwed it out there. So we've got approval from them. We can get these paved and move on to something else.
John, will you go over those roads for us? Do you have those in front of you?
Yeah. I've got, the entire Circle subdivision, which is Black Oak Drive, White Oak Drive, and Pin Oak Drive. And the Signal Ridge are part of that subdivision, which is the remaining part of Signal Ridge Road and River Oak and Lockview Court. Mickey's Road down off of Benson Valley. And I'm gonna finish up the Bentwood subdivision, that entrance there on Burlington and St. James Court and Consumer Lane.
Okay. That sounds like that's in several districts there. Any questions by anybody on the municipal aid? Rural municipal aid. Nice. Okay, seeing none. Thank you, John. Let's move to the next item. The next item is authorization to approve a resolution authorizing and approving directing National Opioid Consortium to vote on the Malink Drought. I don't know how you say that, Counselor. Malink Rock bankruptcy plan with the MDL 2804 National Prescription Opioid Litigation Plaintiffs Executives Committee recommendation. Counselor.
That's a mouthful of a whole lot of truth, Judge. Here's the deal. Mallinckrodt is a distributor of opioids for which is declared, who has declared bankruptcy. And the bankruptcy trustee on this multi-district litigation and the bankruptcy court have instructed the parties to review and present details of how they want to evaluate the bankruptcy. Unfortunately, the deadline is the 2nd, I think, of September, or the 3rd or the 2nd. It's the day before we meet. So we can't get it in there timely to circulate the plan for approval. The plan's an opt-in or opt-out. If you don't approve it, you got to go on your own. If you approve it, then you go in with the rest of the debtors claimants, much that is Franklin County. So I talked to our attorneys, and this particular attorney, Aaron, in West Virginia, and explained to him the time problem that we had and the inability to provide the details. He acknowledged that, and I asked him what he would recommend doing. He said, well, they're all going to approve it, and the bankruptcy court will approve it or not, and asked me to ask the court to approve a resolution directing them to go with what is called to use their phrase, the PEC plan. I always forget their the plaintiff's executive committee's recommendation, which frankly we would have gone with anyway, much like you did on the recommendations of Attorney General Cameron, et cetera. So this is a resolution to allow us to continue to participate in the bankruptcy along with all the other counties and states on this distributor's bankruptcy plan and be able to do it timely with that deadline fast approaching before we can have another court date. So you're basically asking your attorneys or our attorneys on the opioid case to resolve it based on their recommendations, along with all of the other plaintiffs' recommendations once they get the plan formalized. And unfortunately, the details of the plan won't be formalized until a time we can't meet before we have to evaluate that. So asking to approve that resolution, directing them to go with the plaintiff's executive committee's recommendation to participate or not with the Mallinckrodt bankruptcy.
Well, I think it's a no-brainer. We need to participate, let them do it because we don't want to hire an attorney to do it.
And this is part of that multi-district litigation, y'all, that is being all the way from New York, West Virginia, Ohio, Kentucky, Alabama, Tennessee, et cetera. They're all pending in various federal courts, as well as some state courts. But for the majority, they've all been removed to federal court. And then by necessity, the manufacturers and some of the distributors have sought bankruptcy protection, much like you did in Johnson & Johnson, et cetera, a couple of weeks ago. Bless you.
Okay. Any questions for Counselor Sparks? And a bless you to Squire Booth. So any questions? All right. Thank you, Counselor. Appreciate
And
that.
if and when I get those recommendations, Judge, I will promptly forward those
and
immediately.
I'm
with the
promptly
bankruptcy
forwarding
stuff.
them to you because I get them maybe before you.
We get copied the same day, but I didn't want you to do it. I want to keep you on your toes. So please keep
Okay.
doing that. That makes sure that
As soon
you.
as I get them, I'll get them to you and then you're on top of it.
Thank
We
you, sir.
appreciate it. Thank you.
Thank you, Court.
Yeah, okay, you've got a cold check, Counselor.
Oh, yeah. KRS Chapter 514 provides that in enforcing and prosecuting cold check cases, the merchant and the county attorney can charge a processing fee of up to $50. We've kept ours at $25 because frankly, people bouncing cold checks aren't able to pay extra fee money. And this is the balance as it existed at the end of the fiscal year of 2021 or 2021.
Okay.
So asking y'all to take their money.
$445, correct?
Yeah, people are using debit cards more than they have in the past. So we're seeing a reduction in that, which is good. That means, means crime's not happening in that regard very bad.
Okay. Well, if you're asking us, I guess we can take it. Thank you. We appreciate it.
Thank you, Judge.
Okay.
Thank you, Court.
Okay, next item is authorization to approve agreement with the Kentucky Energy and Environmental Cabinet for our 2021 Waste Tire Management Program. Miss Brittany's on the line, and Squire Moore, you've asked about this maybe 6 times, half a dozen times already, and we've got an announcement. Miss Brittany?
Good evening, Court. Yes, Judge, I'm here presenting an agreement between Franklin County and the Division of Waste Management to put on this tire program. What Andrew's sharing is our flyer that I'm hoping to get out to the community starting tomorrow once this agreement is signed. Our planned dates for the fall waste tire collection event are September 30th to October 2nd. It's a Thursday, Friday, Saturday event. Thursday and Friday will be there from 8 to 4, Saturday from 8 to noon, and this event will take place at the State Highway Garage on the west side of town near the interstate. So there are a few things regarding this program. We will not accept any tires from salvage yards or retailers, and we will accept just about any kind of tire, any kind of regular passenger vehicle tire, truck tires, tractor, farm implement, things like that, and they can be on or off the rim. So just asking for court approval for this agreement between the state and the county. The county is responsible for advertising. The state will take care of all of the fees related to disposal of the tires. And at our last event in 2018, we collected 15,000, give or take. So that would be a pretty big bill. So the state's going to take care of that side of things. And we're responsible for advertising. So there is no grant funding. The grants that solid waste does apply for yearly do not include funds for this grant. So this advertising, or for this program, so this advertising would come out of the county's budget.
All right, questions? Andrew, would you, starting the second week of September, tag that to our Facebook and make sure that stays at the top so people can see that? And Brittany, if you would, at one of our other meetings in September, let's bring it back up again to remind everybody what's happening. And all of you, all the squires, anytime you can get that information out, please do. Let's clean up our rural areas.
I will get this up on our social media first thing tomorrow. I actually think I have a post already scheduled. So we'll get that up there and on the county's website. And, I'll put the order in for advertising if that's, if everything's approved. And then I'll email this flyer to you all as well so that you can share it with your constituents.
Okay. I see Squire Sebastian's hand up.
Just very quickly, Judge, thank you very much. I will welcome everyone to come out to the Leavenworth District and drop off those waste tires. I'm tired of picking them up on the county roadside, so please come out to my district and drop them off. Thank you.
Well, wait a minute. Let's be clear. You're talking about the road, the state road department. Just don't drop them off the side of the road, right?
No, sir,
Tell us
Judge.
exactly
what I was
where you
saying
want
is
it to be dropped off, Squire. I think you need to be a little more specific than just drop them off in your district.
River Valley Road.
River, thank you.
No, what I'm saying, Judge, is the State Highway Department
Thank you.
is located in the first district. I am very happy to have that here. And pleased with the work that road crew does for Franklin County, but they are a tremendous asset here in the first district for sure. So, and I can also say that I get out and clean up my roadside and I pick up a lot of waste tires. So it's great to have this opportunity and this program in Franklin County. Thank you very much.
Okay, now we've made that clear. It's don't just
very
drop
clear.
them in district, the first district. Let's take them to the road department out on 127, the state road department. Thank you. All right, that's a great idea. Andrew, we'll work with you on getting that posted. The next item is authorization to approve Farmdale Sanitation District's request for fiscal court to serve as the recipient for a community development block grant with the district as the subrecipient. Miss Annie, welcome.
Thank you.
And you and I sat through a meeting yesterday talking about the CDBG, and oh my goodness. To say the least, it's extremely hard to work with CDBG funds, but this is a great opportunity for the sanitation district to get some money to help the constituents. I'll let you take off from there.
All right, thank you. Good evening, Court. Karen Leverins, who's head of the Water Management Council at the Bluegrass Area Development District, had hoped to be with us. She is scheduled for tomorrow, but then when the meeting changed, she had a conflict tonight. So I told her I'd be happy to field as many questions as I can on this. The sanitation district is not an eligible applicant for a CDBG. They have to go through a unit of local government. That's one of the federal requirements. So as we have before, they're asking us to serve as recipient with them as the subrecipient. So this would be a pass-through. Their engineer has been involved in this conversation and has suggested that the Bluegrass Area Development District would be a great source for them to prepare the application and, if awarded, to administrate the grant for them, because it will take a lot of the costs that the engineering company has been incurring and passing on to the district, preparing the information. The ad will do that at no charge. And then if they are awarded, then they would receive whatever the small percentage of admin fees would be for administering the grant. As the judge said, CDBGs are one of the most requirement-heavy, information-heavy applications that an entity can apply for. One of the positives of that is that when the ad district prepares this application, because it is so stringent, it will also meet the requirements of many other funding sources, such as rural development and some of those other funding sources. So they'll be looking, while they're preparing this application, at all the different funding sources that might possibly be used to put together a package of funding for the Farmdale project. So I'm glad to answer as many questions if I can, and if not, we will find the information for you.
Squire Sebastian had her hand up first. There you go.
Thank you, Judge. I want to thank our grants administrator for all the work that she is doing. I do want to ask a question. You had answered part of the question, if the Bluegrass Area Development District would be able to keep an administrative fee or take an administrative fee off the top of this. And it sounds as if they would. Do you know what the cap on the administrative fee is?
I'm not sure. I don't believe it's a very high percentage, and they only receive that percentage if the grant is awarded and during the time that they're actually administrating that. So all the preparation and the information gathering, and for example, with this grant, they're going to have to do house-to-house income surveys and possibly some environmentals. All of this will be done at no charge. They'll only get a percentage of admin fees if the grant is awarded.
Okay, thank you. I know every year about right after October, that fee is set They set the percentage of what the administrative fee is, so it'll probably be set in the next federal fiscal year, I'm presuming,
Yes,
or
I'm
federal
getting,
fiscal year 2 or 3 down the road.
I'm getting
based on
ready
the
to attend a week-long CDBG training to get all the updates. I believe that's in September, so I will have all that information.
All right, thank you very much.
Great, Ann. Thank you, and God bless you and work. And I know the Bluegrass Head will be doing the majority of this work, but you'll have to get them some information, I'm sure. God bless you on all that one.
Thank you.
All right, thank you so much, Ann. We appreciate your good work. Chief, the next item goes to you, and I am so excited about this opportunity. I was with you on the interview, and this is a fantastic man that is willing to take this job, and we're very lucky. So I'll let you lead. I'll let you go from there, Chief.
Thank you, Judge. Good evening, Court. We're very pleased. When we first posted this advertisement, we were unsure of what type of qualified individuals we might get, but we were in the end very pleased with the individual we selected. Like the judge said, there was an interview panel committee, however you want to say it, but we interviewed 2 out of the 3 applicants. This individual that we've selected has a wealth of knowledge. He's lived his life doing work on big trucks for the state and for the county bus, or the county bus garage. Pretty pleased with his qualifications. Air brakes is a big one. He's got several other qualifications, but we believe that it will be very beneficial to the county and the fire department to hire this individual. That's our recommendation.
Squire Moore?
Yes, I've known this individual a long time. I think he'll be a great asset.
Squire Muller?
Thank you, Judge. So Chief, it looks like this gentleman is still working full-time, is that correct?
That's correct.
And then we're going to potentially hire him for another 24, 25 hours a week, is that correct?
He will not be working full-time. Let me clear that up, Chief. I'll take care of that.
Yeah.
He will not be doing 2 jobs. He can't do that.
22 and a half hours, if I recall that correctly, Betty Joe, is what he'll be getting per week. There's a limit as far as part-time, and he's good with that. He's at the maturity that's what he's looking for, is not working 5 days a week, 8-10 hours a day.
But he's going to continue working full-time with the bus service, correct?
No. I thought I made that. He's not doing that.
Oh, because that's how it shows on the application here, that he's still employed there.
He currently is, but if the court is kind enough to approve his hiring tonight, he will be putting in his paperwork.
Okay, and then one other question before anyone else goes. It says for each other certification, he'll get $1 an hour. Up to how many certifications is there?
We're looking for 2 main ones. The big one for us is the emergency technician for fire trucks and fire apparatus. That's quite an achievement there. Be extremely valuable to us. It would lend to being able to, instead of calling a specialist in at a considerable amount of money, to this individual, hopefully being able to fix pumps and track wiring down for the emergency part of it.
Okay, thank you.
The other one is the ASE. I'm sorry, Squire. The other one's the ASE, which there's 2 dozen. I guess Lambert or Squire Moore can probably tell you that there's a zillion different ASEs, but we would probably want the something for our brush trucks in that line there, as far as if he got that certification.
Okay, thank you. I'll let somebody else go. Thank you.
Squire Tracy?
Thanks, Judge. Thanks, Chief. Chief, quick question. Can you touch on the type of work that you see this position performing, like on the 22 and a half, or on the hours that he's actually going to be on clock?
what we all fear, the road department and us both, is having something unfortunate happen and then the truck's not passing inspection. This guy is certified for CDL inspections. He does them on buses daily, weekly. We would also anticipate the maintenance portion of it when he goes from front to back and inspects the brakes and if needed, repair on the brakes, which we are unable to do according to probably CDL standards on that. There would be work on small equipment such as chainsaws, power units for our extrication equipment, things of that sort that we utilize in the fire service.
Roadside assistance, is that part?
I would hope so. That was one of the questions in the interview. If it's his day off, and you know how things work, it usually will be. We have a truck go down. Would he be willing to come in and trade out that time for some other time? But his answer was absolutely yes. He understands in the school bus world, which he works right now, the importance of having that vehicle be able to perform.
Obviously, the ASE and the EVT certification was mentioned in the abstract. And I know you touched on a few of the ASE certifications. I think there's about 52 of them. So they will be identified by whom in order for.
Was that the question? What certification would we request?
Yes, and are they required for this position? I mean, it's one thing to like to have them, but is it required for this position?
They are not required. We did require that within a period of time that this individual seek that EVT certification because we think that's the most important. But if we get the ASE certain certifications, who knows what will happen down the road? It could be very valuable for the county as a whole.
Right, but as of today, he doesn't have the two mentioned certifications that were in the abstract. Is that correct?
He has,
ASE.
we didn't mention the big or the air brake certification. He's also dealt extensively with the Cummins Insight, which is a program that diagnoses problems on Cummins engines. He's also, as his resume says, or may not say, he has extensive knowledge with Allison transmissions and diagnosing those problems, which we have no knowledge in the fire department for that.
Right. No, I get it. I get it. Where I'm at is, again, I'm seeing what's been recommended, and then I go back to what we have at the road department. I know we have one there that's got an associate's or something in applied science vocation, which would be auto mechanics. So I guess my question in looking at this is, what certifications does the recommended candidate have compared to the career employees that we have on staff, and how we justify that difference in pay? And this may not be you, this could be HR. And then my next question would be is, if our career employees, AKA the road department mechanics, they go and get these certifications, are they going to be able to negotiate? I think that was the word, negotiated. Are they going to be able to negotiate that salary to where they get paid for those certifications? And again, maybe that's HR.
Great question, Squire. I can't tell you what current certifications our road department mechanics have. I can tell you what the guy we're recommending has. I can tell you, according to our treasurer, the difference between part-time and full-time is. And that's about 50% of whatever the pay rate is. So 50% of the benefits is a considerably nice package. We wanted a full-time mechanic. However, it was not to be in the budget. We're good with the part-time, but this individual, if you try to go with comparisons of apples to apples, it's not. There's 50% of the benefits that this individual will not be getting.
No, I totally get it. Again, I'm just asking. And again, as you well know, because you get probably asked every day, usually when somebody talks about their hourly salary, they don't say I got 35,000 in benefits. It's I make X amount of dollars an hour and I should be here. So the benefits are more of an afterthought. So
Judge,
I just want to make sure we're being consistent with county employees. And again, the negotiating part is what stuck out to me probably more than anything. You guys don't get to negotiate a new fireman coming in. The road department don't get to negotiate a new truck driver coming in. So that's just kind of what stuck out to me more than anything.
Point well taken, and maybe mistermed, but negotiation was what it was. You know, the individual is making more than we're going to be offering him. So
not according to his application, he's not.
That tells you, well, it's close. Squire.
No, not according to his
part-time.
It goes back to that benefits and him not wanting to work full time. So I mean, it's
exactly,
you know, it could be a win-win for both.
Yeah, like I say, we're real pleased with the individual, and I understand some concerns on the pay, but we have vetted this through the market of someone who would be an emergency vehicle technician and be able to do all the things that we're asking of him, and the top amount was what we put in the budget. And this individual still has
Hold on, Betty.
to get there.
Right. And again, I'm sure you've done your due diligence, but also I go right back to what I was at a while ago. When I asked, is it required for the position? And you said, I would like for them to get the EVT position.
No, the EVT is required within 1 year. It's in the job description, which you may or may not have.
No, it just says candidate will be eligible to receive increase 1 per hour for each certification. So that's why I asked about the ASE. There's 52 certifications.
Yeah, exactly right. And
so
he wants to choose, but it would be something beneficial for the fire department, which has not been selected yet. The first priority, and it's not an easy one. The stack is this thick on the EVT. The first priority would be to get that EVT.
All right, HR, Betty.
yes, I would like to address a couple of questions or concerns that Scotty Tracy had.
Okay.
Right now, we have 2 full-time mechanics at the road department, so they already have a full-time job. And because the chief did request a full-time mechanic when we got a part-time, so that wouldn't work there. Secondly, John Mitchell can correct me on this, but those 2 individuals was asked last year, the year before, if they wanted to get these certifications for a comp scale that John and I worked on, and they declined the offer. So that was addressed.
I remember that, but it's about 2 years ago, I think.
Yes, and it was offered to those individuals. So, and we do offer that. Unfortunately, not all county employees get paid for additional certifications, only a certain departments. So I wish we could do that. I agree with you completely, Scotty. I wish we could do that all county-wide, but we don't. But currently, certain departments, does receive that. Also, on the job description, and I apologize, I did not bring that with me, but I believe there's 2 minimum qualifications that they do have to have. And I believe the individual already has 2 of the 4, and that's what the chief is referring to. And again,
CDL and that other certification. CDL was one of them, wasn't it?
Yeah. Again, I apologize. I did not bring that job description home with me, but I know there's 2 minimum certifications that was on the job descriptions that they had to have, and he has 2 of those 4. So I wanted to kind of hopefully clear that up a little bit.
No, and I appreciate that. One thing I also think that, and again, thank you for going back, but one thing I also think we need to clear up as well. The 2 mechanics at the road department were offered X amount per hour right now, what I'm looking at is $3 to $4 difference in what they make, plus $1 per certification. So you're looking at potentially $6 difference on the hour. So it wasn't that they were offered, hey, we're going to give you $3 or $4 more on the hour plus $1 per certification. So I think that needs to be stated as well. It was just, we're going to give you $1 more on the hour. And I think that was the big holdup. So I appreciate it. Thank you.
Yeah, thank you. But actually, that was one of the offers. And we went back and we up to $5 on the hour within 2 years.
Plus $1 an hour on the certifications too. So
yeah, but up to $5 an hour though within 2 years receiving those certifications.
Oh, okay.
There was like 2 different options, and we have those documentation. I know John does, but we did offer that.
Okay. Any other questions? Any other questions? All right, Chief. Let's go to well. Let's get him to go to work. Sound like a great guy. We're excited about him being there, and we look forward to his good work.
Thank you, Court.
Okay, the next item on the agenda, Ms. Lawrenson, I think you're on. I know you're on vacation, and I hope you're having fun and listen to all this conversation, this court meeting tonight, and I'll let you talk about the treasurer's financial statement for the fiscal year ending June 30th.
Yes, during the last court, we did present our year-end financial statement as presented to the Department for Local Government. I think this weekend, I lose track of when the State Journal publishes, but the financial statement for Franklin County for the year end will be a published version for the public, available to them either whatever Sunday paper or something like that. But this is the version that will be published as a part of our requirements by statute. And as you know, it's just a different type of presentation than we do for Department for Local Government. That's maybe a little more constituent friendly for how much we receive and spend. And then it also has an offer for the ability to see the information at in a public location, as well as a complete list of disbursements by vendor. So we lived through it. We survived it. We've reported it every month and hashed through it. And this is just another matter of record for our books, and then we'll be audited on it. So any questions or any specific things you'd like to address?
All right, Susan, let's go to receive the treasurer's report.
Again, I just provide a report to go with your court documents at the time that they go out for a matter of reference. Obviously, we're a dynamic concern, living day by day, spending money. So things change every single day since the last court. If there's any questions or concerns that you see, I'll be happy to address those questions.
All right. Susan, we'll end with you there. Payment of claim, maybe let's say payment of claims. Any questions on payment of claims? Squire Sebastian.
Thank you, Judge. I did want to ask a question in regard to 01, which is on the first page, 015040-318, which is the ARPA payroll grouping 1 and 2. Is that for the premium pay?
Yes. Is that right, Tamara?
Yes.
Okay, so that's for the premium pay. Thank you. I also wanted to ask on that same page, 015081-571 building maintenance for repair. We had another repair for the garage door. Is that the same one that was repaired just a few months ago, or is it a different garage door?
This one's the receiving garage door.
No, it's a different door. The spring broke on the door, and the door actually come down and ripped the top 2 panels off of it. So it's just something that happens on a door.
I understand. In the supplemental bills, I noticed on page 1, there is 015070723. There's a $22,000 expenditure for a Jeep Latitude. Isn't that above the small purchase or the purchase authority? Does that have to come to the court? Just asking, and where's the vehicle going to be located?
This one falls under the small purchase authority, which admin code says is what the state rate is. We got clarification from that from Councilor Sparks a couple of months ago. And the Jeep will be used as a pool car between the judge's office staff and the planning and zoning staff. So our solid waste administrator has a couple of conferences coming up. She will use it for those trips. It will be used by the treasurer for some trainings that are coming up. The planning and zoning part-time planner position will use that vehicle. It'll be used by quite a few employees. We've not had a car in quite some time. So the employees are really excited to finally have something that they can use that's reliable and not have to use their own vehicle.
You approved in the budget 23,000 for use of a vehicle for the part-time inspector or the planning and staffer. So since it was part-time and it was under 23,000, it was 22,000. We found the vehicle. It needed to be a 4-wheel drive, so the inspector could use it when they go out, or the planner could use it when they go out. So that's what we got.
Sure. So my question was, I as far as I recall, we didn't change the amount in the administrative code. It was still 20,000.
The administrative code says that the small purchase amount is the same as what is permitted by the state. And it does say in parentheses what it was back in 2007, but it states that it stays commensurate with the state.
Okay, I'll look at that. I for some reason I didn't remember that language being in there, but I appreciate
you're dead on. That needs to be updated by striking that amount, the actual amount.
Yeah, I thought it said an amount in there.
It's been a rubber dollared. And that came up in that code discussion we had 5 weeks ago.
Tracy?
Attorney Sparks, do you have the date on that? That'll be able to be watched. Do we have the date on the admin code meeting?
I don't remember, but whatever it was, we had it.
Probably June 30th or something like that. June 28th, 29th, or 30th, something on that line.
And we pointed out the inconsistencies between those two and indicated that need to be brought in.
Yeah, I think it was touched on. I don't ever think it was agreed upon. I'll go back and watch it as well.
There wasn't.
You're
right.
I've got one question.
Wait, well, hold on. You're right. There was nothing to agree on. That's what needs to be cured. But I mean, or not cured. Right now, it says the state amount. That's the problem.
Right, and that was discussed as well. I think you made mention it had already been in front of us, and that the court had decided to stay at 20 and so forth. So I don't think I think that was thrown out there, but I don't think, obviously the 6 or the voting members of the court make that decision, and I don't think that decision was made. But again, I'll go back.
You're misunderstanding. It is to this extent. It needs to be fixed because there's 2 sections of the code that refer to 2 different things on the same topic. Right. That's what needs to be fixed. Okay. Yeah.
When's the next admin code meeting? How do we call one?
Well, Sherry and I've been working on it for like a year.
Yeah, but I think this right here is a perfect example of why some wasn't for given that extra. But again, my question is account number 97-8001-742, $5,500 in window tinting.
Yeah. We were going to spend probably 10,000 in new blinds because the blinds had fallen down. We decided that it would be better, more advantageous to tint the windows like they did at clerk's office. So we went with window tinting.
They actually started coming down and presented a safety hazard in our occupational tax administrator's office and almost fell on her. And they're quite heavy. They're pretty big. And when they did start to fall, dust went everywhere. And so they also, that we realized, not only do they need to be replaced or, fixed, that they're going to need to be clean. So we decided the less expensive option would be the tinning. And Jeremy did a fantastic job finding it for that expensive. It started out around $7,000 or $8,000, and we'd almost given up. And so he got a really good deal on that.
Squire, let me go back to something you just said. You said this was a reason that you didn't want to do over 20 because of buying.
I never said 20. I never said 20. Please don't put words in my mouth.
What did you mean by you didn't want us to buy
There
a
was
vehicle?
I didn't say a vehicle. I never said a vehicle. Please don't put words in my mouth.
Well,
Again, I'm going to
tell me the
like
words
I
that
said.
you're saying. I'm not sure what
Like I
you said.
said, I'll go back, I'll watch it. And if it was, I know there was there was a discussion about changing it to what the state was to reflect what the state was. But that, to my recollection, that was never agreed upon. So again, I'll go back, I'll watch it. If I'm wrong, I'll be the first to call you and tell you I'm wrong.
I don't think that
So it's okay. Like I said, we're the members of the court. We make that decision. So we'll just go watch it.
okay. So the thing is, Squire Tracy, the code has always said until many, many years ago that it stays at the state's rate. At the time it was adopted, it has in parentheses an example of what it was at that time. But as the state moves it, it continues to move with it also.
Which refers back to what Attorney Sparks said, where there was two problems. So it needs to be fixed. Like I said, one way or the other, it just needs to be fixed and it resolves the problem. So.
Yeah, it just needs to be fixed.
Squire Sebastian?
Thank you, Judge. I still had one more question to ask. It's under supplemental court bills. The fire department has noted that they have been purchasing bleach, which is an important thing right now. I recall that we had approved a purchase of a bleach making machine at the jail. Part of the reason we did that is so that it could supply our county offices with bleach. Anybody know how that's going? We've had that for over a year now, and certainly the timing was great on having the bleach maker because we all needed it. Just wanted to see how that's going and how our officers are being supplied with bleach from the jail.
Is Jailer Bonner on?
He's not, but he told me that if it was needed to give him a text and he'd jump right on. So I don't mind to contact him
Okay,
if you
we'll
would
get
like.
Jailer Bonner on. Okay, Squire Muller?
Thank you, Judge. Just, I guess maybe while we're waiting for the jailer. So just so I understand, is the vehicle that was purchased, was that one of the 4 that was in our budget?
Yes.
Okay.
Yeah, that's one of the 4. Yep. That's the one that you said you recommended that we get, and you made a $23,000. You put the $23,000 amount on it.
I don't remember, Judge. I just remember there was 4 vehicles in the
That's
final
right.
budget. So, yeah, thank you.
That's right. Yes, sir. Okay. Anything else? Okay. Susan, thank you. And please enjoy your vacation. Sorry that you had to do this. Okay. The next item is in other business. We will be having a public hearing on September the 2nd at 4 o'clock. The public hearing will be on the tax rate. It will be an hour before our next fiscal court meeting. Also, in other business, we'll, Andrew, I asked that you pull back up, if it's not already up, River Sweep on Saturday at 10 o'clock down at the Frankfurt Boat Dock. If any citizens, any magistrates, if you're interested, the Frankfurt Boat Club is sponsoring River Sweep at 10 o'clock on Saturday morning. And you may come down to the boat dock area, Frankfurt Boat Dock area, and you'll go out on different pontoons and help clean up the river. And we appreciate the Frankfurt Boat Club being sponsors of this great event. Squire Moore. You're muted, Squire.
Well, I really didn't want you to hear this. But no, you asked me a while back to report back to you on the road situation in Cosgrove. I met down there with Karen, maybe I get this wrong, DeRamo.
Yeah.
And CT McDonald on the 24th of July. And she had concerns of someone getting hurt on her property. And I suggested an easement, and she didn't want to do that because of those fears. So they came to an agreement on selling a portion of it to him for that road, and I got him a name of a surveyor, and that's in the works right now. So I think it's worked out. Keep your fingers crossed. Looks like that she's going to sell him a couple acres of land so that he can have a good road through there, and it won't bother her either. So just keep your fingers crossed. I think we've got something in the works for that.
Well, thank you, Squire, for going out and work and talking with them about it, getting them together. Squire Sebastian, you're next.
Thank you, Judge. I just wanted to share information with the public and with our staff and members of the court and those who are tuned in about the car cruise-in that was held at Lakeview Park on August the 6th. We had over 80 vehicles there, which was a tremendous turnout, given that we were competing with the Hot Rod Nationals in Louisville at the fairground, which is a national event, and cars come from all over the United States for that. We were also competing with individuals going to the US 127 yard sale. So we had a great turnout. Over between $700 and $800 was raised that evening for the fight against cancer, which was absolutely fantastic. So just want to salute folks who came out that evening and participated in a very family friendly oriented event. Want to thank the Cattlemen's Association for coming out that evening and grilling, and the proceeds that were put into that organization will go back and benefit the community. Want to also throw a shout out to Taylor Bell's Ice Cream, a locally high school driven business at the time when it was developed as an ag class activity. And so one of the residents in the first district actually owns that business and operates that. So it was fantastic to have Franklin County supporting Franklin County in a variety of ways, through local businesses, through local associations. A lot of new and old friends were able to get together, and it was a family oriented, and a lot of good money was raised to beat cancer. So we really want to thank everybody for coming out for that. And want to also get on everyone's calendar September 12th. That's a Sunday afternoon. That's going to be the next car cruise-in activity at Lakeview Park at the Carter House. And proceed beneficiary to be named shortly. Thank you.
All right. A couple other items. Tomorrow night is a concert series down on the mall, and I understand that the health department will be there giving out vaccines to those that are wanting a vaccine. So that's awesome. Thank you, health department. The health department will also be at the aquatic park on Saturday to give vaccines to anybody that wants or needs a vaccine. So plenty of opportunities to get vaccines. Let's do what we can to get one. Jake, Mr. Jailer, welcome. See you're in your vehicle. We had Squire Sebastian asked about your bleaching processor. Can you give us an update, because the chief is ordering bleach?
Come get all you want, or let me know and I'll deliver it to you. We make it almost every day. We utilize it a lot. I don't think we bought bleach in a while, but anybody that needs it in the county, let us know and we'll bring you gallons of it.
Gallons of it. Okay. All right. Good deal. Thank you. Thank you, Jake. Hope you're doing well. I understand. Do you want to, it's already come out in the paper. Do you want to make a report on?
I can update to date. Right now we're at 28. We're still waiting on some tests. The test we had to we tested like 100. Don't quote me on the exact number, and then we had to order some more tests. So it took a day to get those in, and then it takes about 2 days to get those back. So I should have all the results back by Monday. I'm hoping it's less than last time, and we're a little better prepared this time with it. It's just something we got to work through, and we're hanging in there. As this time, we have no staff with tested positive, and every been asymptomatic. We got 1 or 2 with some flu-like symptoms, very mild symptoms. So right now, everything, I guess it's as good as it can be, but we're still working through it and working hard.
Okay. Stay safe. Squire Moore?
Yes. Do you offer inmates the vaccine?
Absolutely. We sent out another email yesterday, and the ones that tested negative, they all want it as soon as possible. And we're going to get that through the health department. If they're positive, they have to wait a certain amount of time. I believe it's 90 days. The health department may correct me on that time, but I think that's what I was told today. It's always available, but right now it's a little bit more in demand. So yeah, we'll probably next week vaccinate again. But it's always offered.
Okay. Any other questions?
Judge, I'd like to, can I segue on that as well about some vaccination opportunities that probably nobody's heard about? With the cooperation and coordination with the judicial judges beginning Monday or Tuesday, the 17th, on some other follow-up days, but we're going to have vaccines available for individuals who appear for court sessions on Tuesdays and maybe Thursdays. But we're going to start that on the 17th at 9 a.m. I think they're going to be from 9 to 11 outside of courtroom B. If there are individuals who are making court appearances, they've got an opportunity to get the vaccine if they want it. In addition, if there are any county personnel, et cetera, they're going to be there starting at 9 o'clock on the 17th, and we'll be scheduling some other appearances later on. And I'd like to thank Judge Olds and Judge Mangitt for assisting in that coordination, as well as Ms. Mattingly for her assistance and willingness to do that. Hopefully we'll capture some unserved folks that may not have had an opportunity to get the vaccine, and it'll be available to them.
Thank you. Thank you, Counselor. Any other constitutional officers? Jake, once again, thank you for being on. And department reports. Okay, we wait a minute. Also committee updates. Charlie Lewis. Thank you, Charlie.
Hey,
I got you.
You got me. Thanks, Judge. Thanks, Court. Good evening. Real quick, report from our feasibility master plan study company. We've had 875 surveys completed. According to them, that is great. So we're glad to hear that. They're putting that information together, and we are going to have a park committee meeting August 24th at 1:30, and they'll give us an update on their findings. And that is all I have.
All right. Thank you, Charlie, for that update.
Thank you.
Anybody else? Okay, it is 7:20. We'll take a recess for 5 minutes. We'll be back at 7:25 to go into our voting session. So the court is in recess. County Fiscal Court video teleconference meeting of August the 12th, 2021. And this is our voting session, and we welcome everybody that is watching. And Clerk, would you call the roll?
Squire Sebastian,
Here.
Squire Blackburn,
Present.
Squire Muller,
Present.
Squire Tracy,
Here.
Squire Booth,
Squire Booth, you here?
I'm sorry, I had my mute button on. I am present.
All right,
Thank
okay.
you. Squire Moore,
Here.
Judge Wells.
I'm here too. All right, we've got a special Pledge of Allegiance tonight by Haley and Hannah, 8th grade students at Second Street School.
I'm Hannah. And I'm Haley. And we're in 8th grade. Please stand with us as we recite the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Awesome. Thank you, Haley. Thank you, Hannah, and all the best at your new school year. And let's hope that we can continue to be in school. So wear your mask, be safe, and thank you so much for leading us in the pledge tonight, Haley and Hannah. Okay, the first item on the agenda is the authorization for approval of minutes from a regular meeting of July the 23rd, 2021.
So moved.
Second.
Motion and seconded by Squire Muller, I think. Was that you, Squire Muller? Okay, Squire. Motion and second. Discussion, call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
Yes,
Squire Moore,
Yes.
Judge Wells.
Yes. The next item is authorization to approve the county clerk's amended 2021 annual order setting maximum amount of deputies and assistants.
So moved.
Second.
Seconded. Okay, moved and seconded. Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
yes,
Squire Moore,
Yes.
Judge Wells.
Yes, the next item is the second reading and approval of an ordinance amending the Franklin County Code of Ordinances, Chapter 155, wireless communication facilities by adding small cell systems and towers.
So moved.
Second.
Moved and seconded. Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
yes,
Squire Moore,
Yes.
Judge Wells.
Yes, the next item is first reading of an ordinance amending the Franklin County Code of Ordinances, Chapter 155, Section 155.085, Table of Permitted Uses to include the land use of many warehouses, self-storage facilities as a permitted use in the Highway Commercial Zoning District in Section 155.089, noted special conditions, to add noted special condition number 27. This will be voted on at our September 22nd meeting.
September 2nd.
I'm sorry, September 2nd meeting. I apologize, September 2nd meeting. Okay, the next item on the agenda is also a first reading. This is a reading of an ordinance amending the Franklin County Code of Ordinances, Chapter 155, Section 155.085, Table of Permitted Uses, to include the land use of kayak and canoe, water, trailhead launch, and pickup parking as a conditional use in the limited commercial zoning district in Section 155.146, Section C, conditional uses to add a condition. That vote will be on September 2nd as well. The next item is also a first reading. The first reading of an ordinance amending the table of special ordinances, Section 1, zoning map changes of the Franklin County Code of Ordinances for, excuse me, the 10.01 acre property identified as PVA map number 051-00-00-008.01, located at 505 Jones Lane, from Rural Residential District RR to Agricultural District AG. The vote will be September the 2nd, and also the court has asked for a transcript on this particular item. The next item is authorization to approve a resolution adopting and approving the execution of a rural secondary program agreement between Fiscal Court and the Commonwealth of Kentucky Transportation Cabinet, Department of Rural and Municipal Aid, and accepting all roads and streets referred to therein as being a part of the county road system.
So moved.
Second.
Seconded by Squire Moore. Discussion, call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
yes,
Squire Moore,
Yes.
Judge Wells,
Yes. The next item is authorization to approve a resolution of the county of Franklin, Kentucky, authorizing and approving and directing the National Opioid Consortium to vote on the Malincroc bankruptcy plan with the MDL 2804 National Prescription Opioid Litigation Plaintiffs Executive Committee's recommendation. And I apologize for the mispronunciation.
So moved.
second,
All right, and this is moving forward, actually a lot quicker than we thought. And hopefully this will bring us some money that we can put into jail and help facilitate opioid rehabilitation. So call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
yes,
Squire Moore,
Yes.
Judge Wells,
Yes. Next item is authorization to accept the county attorney's cold check expenses fees, excess fees in the amount of $445 for the fiscal year ending June 30th, 2020.
So moved. Second.
Okay,
okay, so I got Muller and Sebastian,
yeah. All right, call the roll.
Squire Sebastian,
Yes, I sure wish it was a lot more, but we'll take all of it we can get.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Moore,
Yes.
Judge Wells.
Yes. You okay?
you didn't, I didn't get to vote.
You didn't call us on Squire Booth.
I apologize, Squire Booth.
Oh,
So
yeah.
sorry.
Yeah, all right.
You should be.
I apologize. I would never leave
I
you
think she
out.
got choked up on your name,
That's what it
Squire. I
was.
don't know why, but
I'm gonna go
I
grab a
think she did.
bottle of water real quick.
All right. The next item is authorization to approve an agreement with the Kentucky Energy and Environmental Cabinet for the 2021 Waste Tire Management Program.
So
So
moved.
moved. Second.
Okay, Squire Moore, you got the first motion, and Squire Sebastian, I think you've got the second. Okay? Squire Moore, Squire Sebastian, call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth.
Yes,
Thank you. Squire Moore.
Now that our clerk is back in the room, yes.
Thank you. Judge Wells.
Yes. The next item is authorization to approve Farmdale Sanitation District's request for fiscal court to serve as the recipient of a community development block grant with the district as subrecipient.
So moved.
so moved.
Okay, seconded by you, Squire Booth.
Yes, I second that.
All right, thank you. Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
Yes,
Squire Moore,
Yes.
Judge Wells.
Yes. The next item is authorization to hire David Wilhoit as a part-time fire mechanic at a salary of $27 per hour.
So moved.
second,
All right, call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
I've been very open with the fire department during this whole process, and I wish we could work things out with our current mechanics, because I think they're capable of doing it. I'm a no.
Squire Tracy,
No.
Squire Booth,
yes,
Squire Moore,
Yes.
Judge Wells.
Yes. Next item is authorization to receive the treasurer's financial statement for the fiscal year ending June 30th, 2021.
So moved.
Second.
Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
Yes.
Squire Moore,
Yes.
Judge Wells.
Yes. Next item is authorization to receive the treasurer's report.
So
So
moved.
moved.
I heard you, Squire Booth. I didn't hear the Squire Muller, you're a second. Okay. Muller second. Booth made the motion. Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
Yes.
Squire Moore,
Yes.
Judge Wells.
Yes. The next item is payment of claims. Is there a motion to deny any of the claims, or if not, the claims will be ordered to be paid? Is there a motion for anybody to deny any of the claims? Okay, claims are ordered to be paid. The next item is authorization to go into closed session to update fiscal court on open litigation cases per KRS 61.810, subsection 1, subsection C, discussions of proposed or pending litigation against or on behalf of the public agency. No action will be taken, and we will return to open session to adjourn.
So moved.
Seconded by Squire Moore. All right. I'm
Judge,
sorry. Yes, sir.
did you skip 15?
Did I? Did you receive the treasurer's report? Did I?
I think you did.
I've got it.
No.
No?
Squire
I
Booth,
have
Squire
Squire
Muller,
Booth. Have Squire Booth making the motion and Squire Muller made the second, and I had a
and it
full,
was
a-
unanimously approved.
And the 14 then?
No, that was you and me.
Okay, I got off there. I'm sorry.
Okay,
Uh,
I'm glad
yeah.
somebody else is getting a little older, Squire Moore.
I guess so. Yeah.
I may have
Somebody's been eating fruit in here and there's fruit flies flying
I know,
around.
I probably got in your way. I
I
understand.
skipped Squire.
All
Booth.
right, let's go back, and we need a motion.
I seconded going into
Closed session. All
closed
right,
session.
we've got a motion and a second, closed session. Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
Yes.
Squire Moore,
Yes.
Judge Wells.
Yes, we are going to go into closed session, and thanks that we will not be coming back live afterwards. We'll just adjourn from here. So thanks everybody for watching, and be safe and get a vaccine if you can. If you want one, they're available. So get a vaccine if you can. Be safe, everybody. Thank you for watching. We are now in closed session. David.